Hi, I'm Florida foreclosure defense lawyer Michael Wasylik. I'm here today in St. Augustine, Florida, and I'm outside the historic Castillo San Marco, which is not a courthouse. It's an old fort. It's the oldest fort, I think, in North America, certainly the oldest building in Florida. And I'm here in St. Augustine today because I had trial this morning, and it's done. I've taken off my tie, but I wanted to talk to you about an issue that came up today that may help you if you're facing a foreclosure trial. And the issue is, what does it mean to be at issue? The purpose of a trial is to resolve disputed facts between parties to a lawsuit. So if one party says the light was red and the other party says the light was green, the court will hear the witnesses for both sides, will evaluate the credibility, and if it's a jury trial, the jury will decide who they believe. If it's not a jury trial, the judge will decide which witness should be believed and make a ruling based on that. Now, in order for the trial court to know what factual issues are presented to the court to resolve, because some issues are disputed, some issues are not, the pleadings need to be closed. And what that means is that the paperwork that is filed with the court that frames those issues, that defines what those disputed issues are, that needs to be finalized. Now, in a foreclosure case, like most civil cases, the pleadings are the complaint, the answer, and any reply to the answer. And what that means is the complaint is the plaintiff's allegations. The plaintiff complaining what's wrong, the problem they're seeking to resolve with the court. The answer is the defendant's defenses. They either deny them or say, yes, this happened, but this excusable thing happened. In other words, they present what are called affirmative defenses, avoidances of the facts. And then the reply is the plaintiff's chance to respond to those and say, well, here's another fact that actually flips that fact back around and therefore makes it so that we should win. Now, if the complaint is in, the answer is filed, and the reply is filed, and everything is done, and all parties have had a chance to file whatever pleading they're entitled to, then the case is at issue, meaning that it's ready to go to trial because the issues, the factual questions that are to be resolved by the trial court are set in stone. But if there is any pending motion challenging any of those, so for example, let's say the complaint's been filed but the defendant's filed a motion to dismiss, that's not an issue because the motion to dismiss is not an answer. It's a challenge to the legal sufficiency of the complaint, and if that's resolved, the plaintiff has to amend the complaint, meaning they get to change the allegations, meaning the issues that are in dispute factually could possibly change. If the defendant rather files an answer and the plaintiff challenges that answer by saying there's something legally deficient about that, the defendant might have a chance to amend their answer in affirmative defenses, therefore changing the facts. If any of those documents contain embedded motions to strike or dismiss, that takes it out of issue. If there's any party that hasn't yet answered, that still has a right to answer because they've not yet been defaulted, that takes it out of issue as well. And all those things mean, if it's not an issue, it means that the court can't set it for trial, can't go to trial. In fact, can't even issue a trial order. If it does, it's a nullity under some of the case law. So if you have a foreclosure trial pending and you think that maybe it's not ready for trial because you don't really know what facts are in dispute, maybe one of the pleadings is open, maybe there's a motion to dismiss one thing or strike something else. If any of those things are happening, you think your case might not be at issue and you're set for a trial, you have a question about that, give us a call. My name is Michael Wasylik. I'm a Florida foreclosure defense lawyer. I do trial work all the time, and having a case at issue is one of the things I focus on, whether it's at issue or not. Before I go to trial, I need to know what facts are in dispute before I step in the courtroom, and so it's something that I do. So if you have a trial set and you think you have a question about whether it's ready for trial or not, you might need a lawyer to help you out with that, give us a call. Our number is 352-567-3173. That's 352-567-3173. I'm Florida foreclosure defense lawyer Michael Wasylik. Thanks for watching.